In 2025, the UK Home Office has made it clear that visitor tourist visas cannot be used to switch into longer-term immigration routes. Hello, and welcome back to the channel. I am Daily Visa News. I bring updates on UK immigration developments. In this video, I will be talking about immigration changes that threaten the rights of people in the UK in 2025. So, if you have not yet subscribed to the channel, I encourage you to do so. Now let's begin. In 2025, the UK Home Office has made it clear that visitor tourist visas cannot be used to switch into longer-term immigration routes. A standard visitor visa is strictly for short trips. Holders cannot take paid jobs, claim benefits, or make the UK their long-term home. Crucially, visitors must leave and apply from abroad if they later qualify for a work, family, or student visa. Switching from a visitor visa to any settlement route inside the UK is generally forbidden. For example, the Home Office guidance explicitly lists the standard visitor visa among categories that do not permit switching, and notes that anyone on such a visa must leave the UK and apply for a new visa from abroad. Visitors cannot do paid or unpaid work for a UK employer beyond a few limited permitted engagements. They cannot access public funds welfare/benefits, nor stay for extended or successive periods. They cannot convert to a work, student, or family visa while in the UK. Any such change requires exit and reapplication. In parallel, from early 2025, the UK rolled out an electronic Travel Authorisation (ETA) system for visa-exempt visitors. Nationals who previously travelled visa-free, e.g. most EU, US and Commonwealth citizens, now need an ETA before flying to the UK. The ETA is a 2-year digital clearance allowing 6-month visits. It adds an advanced security check, but does not grant any right to work or settle in Britain. In short, the post-2025 system treats the visitor visa as a one-way entry ticket for a holiday or business visit only. The border is closely monitored and the visa clock towards any kind of settlement cannot start while one is on a visitor visa. The rules on naturalisation becoming a British citizen were tightened in early 2025 with new good character criteria. Any applicant who ever entered the UK illegally is now normally refused British citizenship, regardless of how long ago that entry occurred. Likewise, anyone who has previously arrived without a required valid entry clearance, having made a dangerous journey, for example crossing the channel in a small boat or hiding in a lorry, will also be refused. In practice, this means that people who came via regular routes, including many refugees who later settled and were even granted protection, are effectively barred from ever naturalised. Illegal entry. The Home Office guidance states any person applying for citizenship from the 10th of February 2025 who previously entered the UK illegally will normally be refused, explicitly removing the old 10-year look-back window. Dangerous journey. The same guidance adds a person who applies for citizenship from the 10th of February 2025 who has previously arrived without a required valid entry clearance or having made a dangerous journey will normally be refused citizenship. It even defines dangerous journey to include crossing by small boat or being concealed in a vehicle. In effect, the UK is decoupling protection from citizenship. A refugee can be granted asylum or leave to remain, but under these new rules they may never qualify for British nationality if they entered irregularly. This represents a permanent barrier. The guidance says the ban applies regardless of the time that has passed since the illegal entry took place. Critics note this will create a de facto 2-tier residency. Those who entered legally on visas and comply with all rules remain eligible for citizenship, whereas those who used any unofficial or dangerous route are shut out indefinitely. For reference, the official Good Character Guidance on gov.uk spells out these rules verbatim. Until 2025, most work visa holders and Hong Kong British National Overseas BNO visa holders expected a 5-year path to settlement IR, then citizenship. However, the government's 2025 Immigration White Paper proposes doubling this period to 10 years for most categories. In other words, rather than earning indefinite leave after 5 years qualifying stay, skilled migrants may now have to wait 10 years or longer before applying. This is framed as an earned settlement proposal. In theory, high contributors might qualify sooner, but the default qualifying period would be extended. Skilled workers. The white paper explicitly proposes increasing the standard qualifying period for permanent residents, also known as indefinite leave to remain, or settlement, from 5 to 10 years. If enacted, this means an engineer, doctor, or IT specialist on a work visa who assumed a 5-year pathway could be forced to apply after 10 years instead. Per Commons Library notes, only certain routes are exempt. For example, spouses of British citizens and victims of domestic abuse would still qualify after 5 years, but skilled worker routes would not. Hong Kong BNO visa holders. The BNO pathway, launched 2021, was explicitly advertised as 5 years to ILR. The white paper did not clearly exempt this group from the change. The government has said it will consult on how the earned settlement scheme will work and which routes it affects, but as of mid-2025, it is uncertain. Campaigners warn that applying a 10-year rule to BNO migrants, tens of thousands have already come, would break the UK's promise. A petition to guarantee the original 5-year route has gained traction, and Parliament scheduled a debate on the 8th of September 2025 about exempting the BNO scheme from these new rules. It's important to note the ILR extension is proposed, not yet law. The May 2025 White Paper only lays out intentions. Any change will require amendments to the immigration rules and consultations. But the announcement signals a significant shift in policy. In sum, for lawful migrants, the most drastic change is the longer waiting time for settled status, while for those who entered irregularly, the door to citizenship is now shut forever. Overall, the UK of 2025 is sending a clear message. Visitor visas are only for visiting, with ITA entry checks for many nationalities. Illegal or small boat entrants are normally ineligible for citizenship, and even many legal migrants face a doubled residency requirement. As always, these rules are evolving. The ILR changes await finalisation, and anyone affected should seek current guidance.